Drive-Through HR is the place where we talk about HR and politics and other fun topics. And we've got a one of our unofficial, semi-official, I don't know, quasi co-hosts here with us. So our guest today is Jon Hyman. Jon, welcome to Drive-Through HR, and Robin, good afternoon. Great to see you as well.
Can I be
Hello,
a quasi?
I
was going to say,
I haven't been doing
can I be
shows,
considered
so
part of the team when I
you
show
are a
up like
host
once
of
every?
labor-relatedly, Jon. But yeah, so
glad he was able to find his way here.
yeah, it's been a while.
It's been too long. It's good to see you both.
Likewise, yeah. We obviously did a little bit of prep and catch up ahead of the show or before we started recording. But you're a well-known commodity to us and probably to a lot of listeners because you and I have done shows for a couple of years. But for people who may not know you or may be listening for the first time, why don't you go ahead and introduce yourself and tell us about Jon Hyman and your law practice.
So, do I got to talk about myself in the third person? Jon Hyman is. I'll do.
Tell us about you.
I'm a employment and labor law practitioner. I've been in practice since 1997, so I'm coming up on, as I vomit a little bit in my mouth, 30 years of legal practice, representing exclusively, more or less exclusively on the management side. I am and my partners will be mad at me if I don't get this out there. I am a shareholder at the law firm of Wickens, Herzer, Panza in Avon, Ohio, where I chair our employment and labor practice group, representing primarily small to mid-sized businesses on the kind of gamut of on the compliance side, kind of the day-to-day employment law slash HR compliance issues, and then for the businesses that don't have the foresight to call me before they make a decision, on the litigation side as well. Although as I get older, I enjoy the compliance work a lot more than the litigation work. But the litigation work pays the bills. So, and I got one kid in college and one on the way. So keep sending me the litigation work because I'd like to pay my kids' college
There we
tuition.
go.
Yeah, that's the important stuff. In addition to my labor and employment work, I also have a small kind of niche practice representing craft breweries, more as a general counsel type role. So that's not just, although employment law is a wonderful kind of inroad to talk to brewery owners, because they all have employees, and which are kind of the issues that are always seem to pop up on the radar. My practice there is not just limited to employment law, but it's regulatory and tax and real estate and business formation. And I have a team of folks at my firm that I work with that are versed in that stuff, but I've educated myself on kind of the regulatory ins and outs of alcohol beverage law as well. So I have that.
And taste testing
too. And look, you got to go.
Quality control.
There is nothing wrong with being able to have business meetings in breweries and have it actually be like for a legitimate business purpose, not just we're going to meet at the bar for a drink. We're going to meet at the bar for a drink, and we're going to talk about your issues, and I'm going to bill you for them. That's magic. So, while
sampling a flight.
Do you stick to beer, Jon, or have you delved into any other like bourbon? I know there's a lot of. This isn't really a question. I'm just curious. There's a lot of activity where a lot of the breweries or a lot of the distilleries in Kentucky have been having some financial issues.
Oh, I thought you meant drinking, because I don't discriminate on what goes in the mouth.
Yeah, but you don't represent distilleries, right?
Right now, I'm representing strictly breweries. A lot of the issues are largely the same, although there are differences in how wine and spirits are regulated, at least in Ohio, to some degree, particularly with distribution and other things. I am capable enough to kind of represent businesses across the alcohol beverage spectrum, but right now kind of my clients are all in the beer space.
Nice. You're also, since I wasn't very clear when we opened the show, you and I have done a sort of an intermittent sub-podcast here under the Drive-Through HR umbrella for the last couple of years called Labor Relatedly, and you actually are the co-host when we do those together. You're the brilliant legal mind that comments about what's going on. So yeah.
Nobody saw your air quotes around brilliant.
No one did. Just big eyes when I said it. So anyway, Jon and I haven't been doing that for a while because everything kind of stalled out after the election last year, and the board got shut down. But now maybe get back into that later in the year.
The board is back. The board is back, baby.
Baby. Yeah, we're going to start seeing some activity again. So anyway, I think, Robin, that's enough banter.
That is lots and lots of banter. And I think we'll probably end up wrapping up the show we'll get some updates on that labor relatedly side, and we'll talk about the board and that kind of stuff. We kind of wrap up with that. But let's kick off with this, because we are at almost a year now with our new administration in office. And on the HR side, this is still a hot top topic for lots of practitioners, lots of HR leaders. And that is, what in the world should we be doing in HR around these changing definitions, for want of a better word, that we've seen trickling out over the year due to some executive orders, bringing in of some new executive orders, right? There's no longer affirmative action. There's new definitions now within the EEOC to think about, pay attention to. Conflating of DE&I with, lots of air quotes here, discrimination. What in the world should HR professionals be paying attention to, focusing on when thinking about discrimination, interactions with the EEOC, if they're a government contractor, what's happening and evolving still in that world? It's a big question.
I think you filter out the noise. I mean, the thing is, so there's been so much noise, particularly coming out of the EEOC, around their definitions of kind of what is discrimination, what isn't discrimination, and what our priorities are. But the thing is, the law hasn't changed. President Trump and Andrea Lucas, the chair of the EEOC, have said, where, DEI is illegal, DEI is illegal. You can't discriminate against white people in hiring. Well, you can never discriminate against white people in hiring. Right. That was always illegal. And that is just as illegal today as it was a year ago when Trump took office, as it was the day before Trump took office. The Title VII defines race not as protecting black or brown people, but as protecting race, period. Yeah. And so you can't, since 1964, if you hire and I'm going to speak very generally now, because there are nuances to these things, but on a real general basis, if you hire a similarly situated, more qualified, or less qualified black individual over a similarly situated, more qualified white individual, that white individual has a valid discrimination claim under Title VII. That's always been the law. Mm-hmm. Now, what the EEOC has done is made a lot of noise and made a lot of noise in the air, I'm struggling for the right metaphor, but you all get where I'm going. To say that we're prioritizing discrimination against white people, we're prioritizing discrimination against men, and we're prioritizing discrimination against Christians. That's who we're going to protect. Mm-hmm. And those have always been illegal. They remain illegal, just as it remains illegal to discriminate against black people, to discriminate against women, to discriminate against trans workers, to discriminate against Jews and Muslims. All these things are illegal. Mm-hmm. And so my advice to employers, as you kind of look at all of this, is to just filter out the noise and just kind of keep doing what you're doing. If your practices were legal before January 2025, they're still legal. And if they were illegal before then, they're probably still illegal now. And so you just keep, if you had legal practices before, keep doing it. And hiring preferences have always been illegal. They remain illegal. But the core mission of what DEI is hasn't changed. And when I explain to people kind of what the D and the E piece of it, I struggle with how anybody takes an issue with the I piece, the inclusion piece. Why you want anyone to not feel included when they come into a workplace just blows my mind. But and not to get overly political, but I mean, if the last 12 months have taught us anything, it's that the politics of cruelty seem to rule the day, and that's what it is. You're just being cruel for the sake of being cruel when you try to intentionally exclude people or make them not feel included. But on the D and the E piece, the diversity and the equity, the goal here is to open if you think of hiring as a funnel, the goal is to open the funnel up as wide as possible, so you fill as many people into that funnel from as many diverse backgrounds as possible, so that when you get to the bottom of the funnel with the actual candidate that's going to be hired, you increase the likelihood that the most qualified person is going to come from a diverse background. But you're still hiring the most qualified person. So if you have 100 people going into that funnel, if 99 of them are white and 1 is black, the odds are the most qualified person is not going to be the black person, because the numbers don't bear that out. But if you increase the pool of people from diverse backgrounds, from marginalized communities, filling that funnel from the top. And now you have, just to keep it black and white for the sake of keeping it black and white, small b, small b, little w, not big B, big W. If you keep it black and white for the sake of keeping it black and white, and you put more black candidates into that funnel so that, 50 white candidates, 50 black candidates, you now increase the odds that the most qualified person is going to be black. Mm-hmm. And that's what valid DEI looks like from a hiring perspective, and that's still legal. There's nothing wrong with that. And so my words of wisdom to employers who try to figure out, the EEOC says DEI is illegal. Well, it's not, and you just need to focus on doing things the right way, which is don't have quotas, don't have preferences. Illegal before, still illegal. But just try to, if you want a more diverse workplace, fill your pipeline with more diverse candidates, and it's all going to shake out in a perfectly legal way in the end.
Sticking with that theme, that overall theme of DEI for a second, I guess, anecdotally, I've been seeing a lot of reports that one of the fastest rising kind of new charges with the EEOC is around religious discrimination, and largely against Christian, in a lot of cases, Christian, and it leads into, I guess, allegations of retaliation and that kind of stuff. And I know you've written a bit about retaliation in the workplace, and why don't you kind of give us like the Cliff's notes on what employers should be thinking about there? This seems like basic stuff, but it seems to it still catches people all the time, right?
Mm-hmm. Yeah, I mean it's retaliation. I mean it to some extent it feels very kind of natural. So and so accused me of X. Their allegations are bullshit, and so why do I want to remove that someone that I view as toxic from the workplace, and so you remove them. But if there's protected conduct, they complain about discrimination, they file a charge with the EEOC or some other agency, and then on the heels of that, you take an adverse action against them. And adverse action is defined really broadly. It's not just a termination. It's termination, demotion, cut in pay. It's anything that would reasonably dissuade any employee from engaging in protected conduct in the future is defined as an adverse action. Then you've opened yourself to a retaliation claim. Look, I get calls from clients all the time. This employee's a pain. I want to get rid of them. Can I fire them? And it's or let's unpack that. Like, how are you defining pain? And it's like, well, they have these medical issues, and they want X, Y, and Z for their medical issues, or they don't get along with this person, and this person is they're accusing this person of harassment, or they filed this charge of discrimination and it was ultimately dismissed, but they're making her, nobody wants to work with them anymore. They're difficult, whatever. It's like, okay, their pain is protected, right? And so I'm not saying you can absolutely, if you have a legitimate non-retaliatory, non-discriminatory reason to get rid of someone, you can get rid of them, but you better have the paper trail to back it up. Because the issue that I run into all the time is, company gets sued, and then we get into the personnel file, and it's empty, right? There's no write-ups, there's no discipline. There's either no performance reviews, or if there are performance reviews, they're meets expectations going back for 5 years. And it's okay. Where's the paper trail to justify that you had performance problems with this person to justify a termination, other than they did something legally protected that you didn't like, and now on the heels of that, you don't want them in your organization anymore. And so you got to have the paper to back it up. Judges and juries don't like supervisors, managers, business owners coming in and saying, Jimmy did X, Y, and Z, unless there is a contemporaneous paper trail that preceded their protected conduct to back up the fact that Jimmy did X, Y, or Z.
What are the best tips then for managers? What should HR leaders be training their managers in on how to
documenting everything contemporaneously? I mean, that's really what it comes down to.
Yeah.
The problem is that particularly, in some of the small businesses that I represent, we're a family. We run everything loosey-goosey. We're not that formal. We don't document things, which is great until you need the documentation. And then it's like, well, where is it, right? I can't defend this claim without the paper to back it up.
Yep.
And so I think if I was going to give managers and supervisors, if I had them in like a employment compliance boot camp, and if there was one thing they were going to walk out of that boot camp having learned, it's the importance of documenting everything contemporaneously. And I get it. It's like it's a pain to write employees up for things, and it's a pain to create paper trails and make notes, and it takes time, and on top of all the other things you got to do in your function of actually on the operational side of the business to keep the business running and keep your employees working and producing the widgets they produce or whatever it is that the business does. And I get all that, but a business owner, a manager, a supervisor is not going to understand the importance of this contemporaneous documentation until it bites them in the ass, and by then it's too late. And so it's just take the 5 minutes to make the note, even if it's a discussion with the employee, like you did X, Y, or Z, and we got to do A, B, and C better. Take the time to confirm it in an email, confirm it in if you use Slack in a Slack message, in a text message, if that's how you communicate something, or just even a note that you put in a file that you keep in your desk. If I can prove that it was done contemporaneously with that it's your ordinary course of your workday to keep these notes contemporaneously in this practice. Even that's better than nothing. But you got to have something on a piece of paper that shows that this was a problem when it was a problem, because otherwise no one's going to believe you.
Yep.
I wonder how far away we are from not needing paper, John. And by that, I'm going to pivot into AI a little bit here.
We're all going to wear little AI chips on our lapels that are going to record everything we're doing.
Video glasses.
Baby.
Like I use AI now a lot of times, like in a verbal, in a voice mode, just to record ideas. I just log them up. You know what I mean? To just save them, as opposed to putting them in my to-do list or my daily reminder. And then I pull them down, but it also kind of helps me collect them. I realize there's some discovery issues and stuff if you're dumping privacy issues if you're dumping AI out there, but really it is becoming a part of the workplace in all sorts of ways. We're using it at LRI. I don't know how you guys use it in your firm, but
we use it. We've
quite a bit.
I run the AI subcommittee at my firm, and we've now invested in an enterprise, or I guess they call it a business tier ChatGPT account. So we're kind of getting our feet wet with AI, but I every day.
I'm doing a presentation to a large employer next week about some of the ways we use it around labor relations and employee relations stuff. So it's out there. But you've written about it a bit. It's definitely being used in hiring, performance management, discipline. But it's still a bit of the wild west. What legal advice for HR folks with AI, especially in light of maybe thinking about how things will change in the next couple of years, technology-wise and tools?
I can't even. My brain can't get around what the technology is going to look like 2 years from now, because if you go back 2 years, it's so much.
I know.
So much. I mean, I think generative. Well, first of all, when we talk about AI, we really got to break it down to two different categories of AI. There's like the AI. There's like kind of like the algorithmic AI. For example, if you're throwing a whole bunch of resumes into an AI for the AI to help you filter out like the resumes that are best suited for a particular position, that's kind of the algorithmic AI to help businesses make decisions in hiring and other things. So that's kind of area number one. Area number two would be the generative AI, using AI to actually help you perform your job function. Help me draft this agreement, draft this email, write up this disciplinary notice for this employee, like that kind of stuff. So it's really two different categories of AI. As we think of it all, I mean, I really believe that AI is still very much in its alpha phase right now, even though ChatGPT is on version 5.2, I think. But I think it's really alpha in its release. And I think 2 years from now, I'm not sure. I don't have the mental capacity to extrapolate where we're going to be. You can think of like the science fiction, right? Like the Total Recall, the old Arnold Schwarzenegger kind of Total Recall kind of type. But I can't think about where it's going to be 2 years from now.
I would think that the Workday lawsuit is going to, the collective, claim is going to have a big impact on, I guess, that algorithmic AI.
Oh, it's sure.
Right? And as we see that kind of play itself out, which will be interesting to me because I believe they're using sort of the disparate impact analysis, which this current administration has sort of said, oh, we're not going to use that anymore.
Right. That's exactly right. So, no, I think you're exactly right. So that lawsuit is going to have, I think we're beyond the point of an employer being able to say, well, that's my vendor and that's not my responsibility, because it is clear that that is the employer's responsibility. And so from the algorithmic standpoint, you better know kind of what vendor you're using and know that the algorithms that they apply to the data that you provide them. I mean, you need to ask, like, has this been tested for impact? Like, show me your impact analysis. Like, has this been tested? You want to see that before you sign a contract, because if the algorithm is going to have a disparate impact on race or on sex or any other protected class, you as the employer are going to be responsible. And the fact that it was the third-party vendor's algorithm that created the impact is not going to provide you any defense or any relief. On the generative side, kind of the using it on the day-to-day, write this for me, analyze this for me, et cetera, every employer, every business in America needs to be asking themselves, like, do we have an AI policy? And if you don't, you're already probably 6 to 12 months too late, because I guarantee you, whether you've authorized it or allowed it or not, your employees that kind of work with data, work with computers, are using AI whether you know it or not. So you are better off having policies. You have to have policies that tell your employees kind of what to do.
And
Yeah.
Not to cut you off, but like literally, you're talking about 2 year span and how much 2 years down the road will be different. I wrote for LRI where I work. I wrote sort of an AI policy a couple years ago because we were delving into it, and Phil, the guy that owns the place, asked me to put something together. So I wrote not really a policy, but more like a how to use AI, but it had some guidelines in it about what you should do or shouldn't do related to proprietary information, that kind of stuff, right? I went back through it, I don't know, about 2 months ago, and I would say like 80% of it is obsolete because of the speed with which AI has changed. I had a whole thing in there about creating images in Mid-Journey through Discord. And I'm like, I haven't used that in like 18 months. So, but back then, ChatGPT didn't create images. Now you can do it. Anyway, so I guess the point.
But question for you.
Yeah.
On a scale of on a percentage scale from 0 to 100, how many employers in America do you think still have social media policies that reference MySpace?
Yeah, a lot.
Yeah.
Probably. Yeah. And I remember these same discussions over social media back in the day. We'd answer these questions at SHRM events all the time, and we had when we were talking about social media and what kind of policies should I have and blah blah. Yeah, this feels like a repeat, but it's on steroids compared to what social media was back in the aughts. We got about 6 minutes or so left, and I know you got a hard stop, John. So I want to get through I want to dip into labor. Mm-hmm. So first of all, what's your take on the board having a quorum and the where we're at? Just real quick, how you feel like we're going to start heading in a better direction now, or got to be better because they're just doing stuff.
I think a functioning agency is better than no agency. So, for sure, I think I think having a functioning agency is a good thing. When you look at kind of what the current board in terms of priorities, I mean, like CMEX is probably going to be kind of high on the list of things that this board is going to look at to undo. And look, and we've talked about this before, but the board, I mean, it's a political body, and it does kind of twist in the political breezes. And it's right now you have a Republican in the White House, and you're going to have a Republican majority board, and they're going to institute policies that are pro-employer, not pro-union, and depending on where you fall on the pro-management or pro-union spectrum will dictate kind of how you feel about the policies that this current board will adopt through their kind of enforcement priorities, through their general counsel, and then through the decisions that this board reaches when the issues ultimately get to the board in decisions. So as we fall on the pro-management side of the spectrum, I think we'll be happy with the decisions that we see coming out of.
Well, I wrote something the other day, and I called the board a pendulum agency, right? Because they swing back and forth, and they've done that since the Obama era, and probably before, but I mean, it's been really magnified since the Obama era. And now that the board, all these cases testing constitutionality, circuit splits, between the Fifth Circuit and others, Thrive, all these different things. a lot of people seem to think, oh, this is going to be better, now that and President Trump removed Gwynne Wilcox. Apparently, that's going to stand. I know it's not definitive yet, but it looks like it'll stand in Supreme Court. So we could wind up in theory, and not maybe worst case, best case, with 5 Republicans on the board instead of the traditional 3-2 split. I have a feeling a bad feeling in my chest that'll actually increase the oscillation or the swing, because it'll just make every change more extreme.
Yeah, you don't want to operate. I mean, nobody wants anyone operating in kind of an echo chamber. And I think, and while I said we'll be happy with the policies because they're going to be pro-management policies that are coming out of the board through their decisions, you do wonder whether the swing is a good thing or a bad thing. And if employers need to pivot their own internal policies, right? It's great for people like me that get paid money to write employee handbooks every time the board changes the rule on, whether a handbook policy does or does not infringe on an employee's right to engage in protected concerted activity. Every time that policy changes at the board, a company has to rewrite its handbook, and there's another few grand in John's firm's pocket because we got to rewrite the handbook for you. So yay for the employment lawyers, but you question whether that's good for business. And I mean, it's a kind of a loaded hypothetical question, but it's not. I mean, these swings are not good for business.
Yeah, because you want some stability and continuity and understanding how to structure your policies and stuff. You don't want to be changing them every year.
Right.
Yeah. To your point, it becomes expensive, and it also creates a lot of conflict and misunderstanding in the workplace that isn't, it's maybe not quantified in a cash way, but it definitely is there, and it creates uncertainty, and that doesn't help business either.
Yep.
Robin?
Yeah, so speaking of kind of a last question here, I guess, before we really start to wrap up, but protected concerted activity. And also thinking about Michael's historical, trip down memory lane for us with social media and everything. Thinking about protected concerted activity. Now, I mean, again, these channels that or mediums that employees, will complain on, right? You've got Slack, you've got texting, you've got social media in the public. What's the top tip for employers when they think about protected concerted activity versus, and they question, or is it conduct that could still be disciplined?
I would say don't think of it and kind of take it out of the legal, is this
okay?
Protected concerted activity. I would say focus on the damage to the business.
Okay.
And say, is what the employee is saying, does it have the real ability to cause harm to the business here? And if it doesn't, let it go. Because often what happens is, by disciplining an employee or firing an employee over something they say or do, either on the shop floor or particularly online around in the community, you are amplifying the communication and making it worse. And so you need to question: do you want to put a megaphone or a microphone in front of the employee's mouth and give them the opportunity to amplify it by making a big deal out of it, by disciplining them, by firing them? Or if there's not tangible harm, then I would say you're probably better off just letting it go, because particularly in the way social media algorithms work, something doesn't get clicks and views is going to disappear in the span of less than a day. And so, are you better off just letting it die out than giving that oxygen? Than feeding it oxygen and letting it breathe and live and carry on. So that's, I think, is from a business perspective, how I like to kind of orient clients to looking at the issue.
Yeah.
You made it through an entire show without talking about the status of Starbucks. Not going to go there. No changes. Lots of stuff happening, but no changes. There's still no contract. Anyway, it was great to have you back on the show as a guest and to catch up with you, John. Thanks for doing this today.
My pleasure. Good to see you guys as always.
Yes.
We will catch up with you again soon, and we're trying to come up with a catchy closing phrase. So that concludes the lunch menu at the drive-through today. So that's it for drive-through HR.
I think that needs work.
Needs some work.
Yeah. We're workshopping it.
Yeah, live and in person. Anyway, have a great day. Talk to you later. Thanks, everybody.
Cheers.